nine-part scares taxpayers, and we're trying to be as friendly as possible. We change it to Special Tax Investigation Department, which deals with money laundering and counter-terrorist financing specifically, and also the NIS currently, right now, through the reforms that has just been carried out, trying to curb the IFF flow from the country, put up what we call the Process of Crime and Illicit Financial Flows Coordination, which now is designated, the NIS has been designated as, the coordination center for the fight against IFF in Nigeria. Time. Sorry. Okay, let me quickly do close up. Yes. We'll also ensure that we play a critical role in ensuring that Nigeria conforms with the FATF standards, conforms with the UNCAC. Most of the time we join for the UNCAC convention. We are also part of the GIABA plenaries when it comes to international cooperation and so on and so forth. Wow. Thank you. I'm limited by time.
Thank you very much, Prof. Idris. I believe that in the room, people would like to listen to you to have this information, but we are time constrained. I will give the floor to the representative of private sector like me here to give us his perspective on cross-border investments. But I like what you said about this invoicing that remain a challenge on illicit finance. I think when you will give your perspective, you will take the floor immediately to bring what will be the solution. And we come back with a quick solution to this challenge before I go to the room to take 1 or 3 questions. Please, you have the floor.
Okay. Thank you very much for the question. And good afternoon once again, everyone. So from the perspective of we lawyers, international lawyers that advise on cross-border transactions, one thing that is clear is that illicit financial flows, they rarely announce themselves. They're actually designed to blend in with legitimate capital. So we have to be very, very careful when we structure transactions to ensure that there are not hidden things behind that actually constitute illicit financial flows. So what exactly I want to focus on is like major drivers for illicit financial flows in international transactions. And the first thing that we see in practice is that there is like a consistent use of structural complexity as a concealment tool. So what this means is that particularly like in energy-related transaction or world structuring or any transaction that has like a cross-border element, parties actually come together to structure it in such a way that the ownership is concealed. So you have multi-layer ownership. You have SPV being set up in different offshore jurisdictions. Some of those jurisdictions, they lack like real compliance mechanisms. Some, like the representative from the NRS, they actually have like tax evasion and tax neutrality and all of those things. So we find out that people come up with these structures to actually disguise the ultimate beneficial owners or to disguise the actual, like essentially make the transaction a sham such that you don't really know what exactly that they are doing, but on paper it appears that they're actually entering into a legitimate transaction. And another driver that we see in practice is the regulatory fragmentation across multiple jurisdictions. Because they are cross-border, of course, that means we deal with more than one jurisdiction. We have many jurisdictions in place. And these different jurisdictions, they have different AML standards, they have different disclosure requirements, they have different compliance requirements and all. So what people do that we find out in this space is that they find the loopholes in different jurisdictions due to the regulatory fragmentation, and they like maximize these loopholes to actually conceal whatever transactions they want to do to generate illicit financial flows. And the third thing that have been discussed like from time to time in the course of the conversations we've had today is deficit in governance. And that's also something that has been mentioned. Corruption has certainly like put us to where we are today. Like if you see governments actually being involved in some of these transactions, and they are seen in the use of maybe inflated contracts, in the use of some multilateral agencies that are not disclosed, in the use of certain key contracts that are also like embedded in transactions that we can't really find their true impact. So all of these things moved together, they actually like make it difficult. But as lawyers, this is where we come in, and I think I want to talk about the solutions that we offer. just before we go to the other panelists. So as lawyers, one thing that we have to bear in mind when we are dealing with transactions of this nature, particularly international transactions, is to ensure that before we take on these transactions, we conduct enhanced due diligence. We are mandated by law to do this, and our enhanced due diligence should actually go beyond just filling KYC forms, because of course, we can have that on paper. We actually have to interrogate the legitimate concern, the legitimate intention behind transactions. We have to interrogate the source of wealth, the source of funds for any transaction that our client brings to us, and we have to interrogate and know that we know ultimately the ultimate beneficial owners, such that anything that they are trying to keep within themselves, we are able to flag. And if, based on our due diligence, we see that, okay, the risk is actually very high, we have to come to terms with making the difficult decision. I understand that we have the cab rank rule that mandates us that, okay, we shouldn't decline clients, but at the same time, when transactions come our way, we have to make sure that the transactions are legal and they will act within the boundaries of the law at all times. So, irrespective of the fact that, okay, we have clients coming to us, if our due diligence actually see that, okay, these transactions are a sham, we have to make the difficult decision to actually turn them down.
Thank you.
Thank you very much.
Thank you very much. Dr. Lado, I think you should take the floor and give us quickly the solution or recommendation from your side, because I would like to listen from the room.
Good, thank you. I think in terms of solutions, I will just mention the elements that really support implementation. Because it is one thing to have UNCAP, to have the 10 principles, and to have the SDGs, but what happens actually on the ground? That is the most important. And in that regard, I will mention the opportunities that we have at the Global Compact for all our members. For businesses that join the Global Compact, they have the opportunity to meet, to connect, and to have that dialogue that we were referring to, the national level, or at the global level or regional level. Even set up a private sector space. COSP. There is a COP, there is a COP for climate. There is a COP for anti-corruption as well. That is called COSP. And the 11th edition was just last year in the Middle East, and we set up a private sector forum there to enable that space for dialogue, cross-regional dialogue, so that people can really move forward with the relevant rules regarding anti-corruption and fighting illicit flows. Another element is the accelerators, because we need businesses to have hands-on experience in fighting corruption. They have to commit for due diligence, to commit for practices, to commit for rules and policies, internal policies that address the issue. So we have accelerator. We are starting this year an accelerator on business integrity. We will be onboarding and running businesses by the end of this year and start actually in March 2027. Another element, and I will end there, is actually it is more open actually to all businesses. It is the academy that we have online. Every year, more than 250,000 people connect to our academy to learn on new and emerging issues regarding anti-corruption, regarding illicit flows. So that is an opportunity really for people to get on top of those topics that are changing. We are in a shifting global order, and I will call on any of you who has a business to join the Global Compact to benefit from those opportunities.
Thank you very much. Dr. Laden.
Thank you very much, moderator. I think moving forward, I would like to state that African states are known to have this positive, result in terms of signing and ratifying, international treaties, whether globally or at the continental or regional level. But demonstrating their political will at the national level for implementation has always been a battleground. So you cannot actually be a state party to AFTA framework or to any ECOWAS trade-related framework, you know, and then you cannot actually put implementation measures on ground. For example, if you take the risk of customs fraud or custom paperwork actually fraud, misinvoicing, misrepresentation, you know, these are actually matters that have to do with state responsibility to digitalize customs paperwork, because it will reduce corruption. It will also arrest partly, I will not say fully, it will arrest partly, the processes that are being manipulated by criminals, you know, in order to actually make a misrepresentation or to actually promote misinvoicing, you know, in the process. And I think if you digitalize custom processes, you reduce partly the factors responsible, you know, for this risk involved. The second point also has to do moving forward is it is not enough for country A out of 55 countries in Africa or out of 15 countries in West Africa to embark upon harmonization of trade regulations and policies. It is not enough. So all member states to any treaty within the continent or within the region, whether AFTA or ECOWAS, must all demonstrate political will to engage in harmonization of trade regulations, you know, and processes. This is very, very important because otherwise criminals will find the loopholes, you know, in jurisdictions that have not harmonized, and therefore they can exploit it, and it will be back to square one.
Thank you, Prof. Ladan. Prof. Idris.
One of the problems, yes, I'll state one problem and how most of the time I see that we should solve it. Nigeria currently trades as the second highest country in terms of Bitcoin. Bitcoin, having studied that aspect of the economy, we realize that is a major means of IFF. And this can be curbed. Nigeria is already working on a VASP bill. The NRS assumed some authorities to itself, but however, in the interest of interagency cooperation, we were conceding to a new draft bill of which both the CBN, SEC, NFIU, FIRS, their responsibilities will be designated. Secondly, we must integrate data. There's no reason why we should have BVN, the driver's license, the name, the team, and so on and so forth. For the purpose of we investigators or law enforcement agency, at the dial of a button, I should be able to see all your details, all your tax details, and one of my major concern is how we treat the NIMC database in Nigeria. I don't see any reason why that agency should not be submerged or designated under the National Security Advisor Office, because it's a national infrastructure. National infrastructure, it will ease the curbing of the fight against economic crime. It will help us be able to estimate IFF from the Secretariat, which I had, which is themselves at the National Revenue Service, Nigerian Revenue Service.
Thank you very much, Prof. Idris. I will go back to the room for you if I can get 1, 2, 3 questions. Unfortunately, I'm also a panelist, but I couldn't give what I think. But I know that you are a professor. I will suggest that each panelist send to us his presentation. We put it together for you. So, quick question. I see for Dr. Kayode. Another? So, we give him the floor first. Well, okay. Somebody behind. Somebody can help us to share the microphone. Okay. So 1, 2, and 3.
Good afternoon, and thank you very much for such an excellent conference and brilliant deliveries and papers, solutions, etc. My concern is we seem to have got the law right, the frameworks right, but you cannot enforce law when people strongly believe that government is not working for them. And therefore, there's a nexus between law and political economy. Our states are largely fragile. International law is brilliant, but international law must be a handmaiden to national economic sovereignty. And it seems to me that looking at Nigeria as a point of contact for the rest of Africa, perhaps West Africa, we are struggling to deliver public goods. And so the contract between the citizen and the state is very weak. And until we resolve that nexus, it seems to me that the brilliant legal architecture that we have put together, and I commend the president of the ILA and the ILA for such an excellent conference, and the wonderful speakers. But I want us to commit ourselves to governing ourselves better and ensuring that the citizen sees the benefit of being a citizen. And I think that when people feel that government is working for them and their society is prospering, we will need less laws. There's no point having a raft of brilliant laws which are not going to be enforceable because people won't obey those laws. But I think that we need to look beyond legal architecture.
Thank you.
And look to economic sovereignty. Thank you.
Please, can you introduce yourself, please?
I am David Okurududu. I'm a researcher from the University of Warwick.
Thank you very much.
Thank you.
Dr. Kayode, here. So that we take the answer together to save time. We are running against time.
Thank you very much, the panelists, for your beautiful interventions. Dr. Sijade Kayode, MNI. I'm a private legal practitioner and Vice President of the Chamber of Commerce and Industry. Professor Ladan, thank you so much. I was expecting part of your contribution from the panelists, but you did that at the last part. We lawyers, we go to court every day. We know where the problem is. We know where the loopholes are because we defend some of these people who are involved in these crimes. Now, two things. The first thing is that there has to be a political will to fight IFF. That's the first one. Because IFF cannot thrive without the connivance of public officials, public agencies, with the private sector. I'll give a scenario that at our ports today, physical inspection is still being done on containers coming into the country, while we have digital scanners at these ports. But deliberately, the scanners are not being used because there is a toll being paid on each container that is physically inspected. Why is that? Because there is no political will. Secondly, my brother from the NRS, we know that to cope IFF, the best solution is to deploy technology, cutting edge, affordable technology and innovation. That is the only way to go. So I believe at the end of the conference, there will be some form of communique, some policy based to government on this. Thank you very much.
Thank you very much. The third one, and I will stop. Okay. Women voice, God voice. So I'm seeing two women. So after you, we come down and we'll give the floor to the panelists to respond.
Thank you very much. My name is Felix Obiom. I'm from the NFI. My question goes to Idris from NRS and his brothers on BO, Beneficial Ownership Register. We all know that the opacity of the BO register has continued to enable IFF. Despite all the laws, it teases off from his question, despite all the beautiful laws, the NEPSA, CAC, NAT, and NRS. So my question is, what mechanism do we adopt to incentivize entities to adopt a transparent ownership process? And Dr. Lado, there have been excellent domestic PPP platforms all over the world, and you have also highlighted some. How will ILA help in translating these domestic successes at the regional level? Thank you.
We take the, no, please, let us take the two ladies as I have to handle in the next 10 minutes, and then we will take the floor to answer.
Okay. Good day. My name is Peculiar Orilade. I am from Afe Babalola University. My question is for Professor Ladon. So you spoke about the risks associated with every framework, whether the AFTA framework or the ECOWAS framework, that there will always be risks associated. However, would you say that if the framework could be made tighter, that some of these risks would be curbed? That if in a situation where these frameworks, even down to the enforcement provisions, could be restructured or some developments could be made to it, some of these risks could be reduced and not to the extent that it is currently. Thank you.
What did he again? This one? Here, please. Behind you.
Thank you very much for giving me the floor. My name is Oluwatosin Ngohe. I'm a Senior Research and Legal Affairs Officer from the ECOWAS Court of Justice. I just want to thank the panelists for their very insightful contributions to this important topic. My question is to Mr. Idris from the NRS. I would like to know, how do you reconcile the need to conduct investigations to ensure compliance with tax obligations with the protection of internationally recognized human rights of citizens, especially as several rights could be implicated while you're conducting your investigations up until the time of prosecution. What exactly do you do, when it comes to violations of rights to property, rights to a fair hearing, rights to due process, and the right to privacy, for example. So how do you reconcile your need for these investigations with the protection of the rights of the citizens? Thank you.
Thank you very much.
So I'll first respond to Mr. Felix, the Chief Counsel of NFIU. I know he asked that question to elicit because he's an authority in that. For BO, which is being championed by NFIU, since the FIU is Secretariat for the IMC, we've also, in conjunction with the FIU and the CAC, carried out recently a study and also preferred solutions to how we can improve BO in Nigeria. Improve in the sense that most of we understand that our BO is comprehensive, but comprehensive to what extent? Comprehensive to what extent? So it is now the purview of the law enforcement agencies while carrying out investigations to ensure that that the true BOs, because there's the difference between a nominee, right, and the true person with significant control of such companies. So in the course of carrying out investigations, we confirm who the person with significant control is through following the money, and then ensure that there's a feedback platform, which is like the authorized officers committee, which can be either designated at the FIU or the CAC, when law enforcement monthly, weekly, or quarterly can come and give feedback on the companies that are being investigated for the purpose of ensuring that the BO register, the central BO register, is being updated with the true people with significant control. And as for the lady from ECOWAS court, can you know that whatever investigations we're carrying out is we have to abide by a legal framework that establishes how we carry out our exercises or investigations. For example, for us to sometimes confiscate assets, we need to approach the court. The court needs to permit And but because I'm time bounded, I can't start expressing what process and how we go about. But mind you, the Nigerian Revenue Service is a law-abiding organization, and we don't go beyond whatever has been prescribed in the legal framework. Thank you.
Thank you very much, Prof. Lada.
Thank you very much, MC. The first person that asked the question on the nexus between international law and citizens' participation, government not working, I think, sometimes we also need to be fair to ourselves. Law is needed at each and every point in time in the life of any nation, because you need law, not just for this resolution. It's an outdated concept. You need law today in the context of fighting money laundering, combating illicit financial flows, and then in ensuring that the promises of treaty obligations under whether after continental level or under the ECOWAS scheme are progressively realized. You need law because you can manipulate. In fact, I always say we do manipulate law. Yes, we do, and we can, because we can use law to respond to any conceivable problem or challenge, including the economic challenges you mentioned. But the point actually is the political will mentioned actually by Dr. Kayode. That's the second question. I'm linking the two together. The idea actually is that if you go by section 14, subsection 2, paragraph B of the Nigerian Constitution, it talks about the primary purpose of government in Nigeria is to promote the security and welfare of all people. One sentence. You don't need any lawyer to translate this. You can read it. Even some, a student of history does not need any lawyer to interpret or translate. It's very simple, clear language. But how many of us even try to understand this constitutional responsibility, which I always say it is an absolute constitutional obligation. It does not require a corresponding right of Nigerians before the government actually discharges this constitutional obligation. So you see, this is why you need law, even to address the economic challenges you mentioned. But the political will is what Dr. Kayode mentioned, and I agree with him in that context. Okay. So I believe that if you also take the role of even domestic law, constitutional law in particular, Nigerian context, section 14, subsection 2, paragraph C of the Constitution of Nigeria provides for the right of citizens to participate in governance. How many of us are even aware of this provision? Do we disseminate it? Do we empower citizens? How do we even get a political will in this context? 14.2c, check it.
Thank you.
And finally,
okay, thank you. Please let Dr. Lado also answer, and then the last panelist, please.
Yeah, I can see how we are suffering because of time. In the interest of time, thank you, sir, for your question. I think the shortest answer that I can bring to you is let's connect with our office in Nigeria, because their role is really to break down those global dialogue spaces into national dialogue spaces, connecting with the national law, connecting with the national development plan, connecting with the cooperation framework between the UN and the country. So, and they work with business association, academia, they work with. So, I would just recommend that we exchange contacts, and I can connect you with our office.
Thank you very much.
In Nigeria. Thank you.
Thank you.
Thank you very much. I don't think any question was addressed to me in particular.
We can give us your last
but I just want
final voice for this discussion.
Okay, thank you. I just want to enjoy everyone, particularly the researcher from Warwick. The question was really, like he spoke to me personally, but at the same time, just like Professor has said, like we need the law, and as much as possible as citizens, we should try our best to keep to our own bargain. Respect the law, and as lawyers, just like I mentioned earlier, we're in a position to like sieve out some of these things, and when we see, we shouldn't shy away, but do our part to ensure that we curb illicit financial flows as much as possible. Thank you very much.
Dr. Lado, final voice, final words?
One word, it is prevention. Prevention.
Thank you.
Due diligence, risk assessment for businesses.
Thank you. Prof. Oladan.
My last word has to do with the need for African actually states to demonstrate political will to discharge their treaty obligations within their constitutional responsibilities.
Prof. Idris and Abrodi for pushing pressure on you. We would like to listen more from what you explained.
So integrate data, fund our law enforcement agencies, and also interagency cooperation. Thank you.
Thank you very much. I have my microphone, MC, as I'm representing private sector here. I think take from this discussion, we need to understand the existing policy, because what we discover is people lack of information. They don't know how to use the information and how to take opportunity from the information. What I take from this discussion is digitalization. Tax office, custom office, at the border, how can we digitalize and have transparency and integrity? And also having a very strong, permanent regional public-private that is bringing all the stakeholders together. But from my perspective, representing chambers of commerce and taking into account what the Global Pact representative just said now, I think that chambers of commerce are compliance. We can set as a compliance enabler. Compliance enabler because government already know that we are the legal advocacy platform, and we understand that we should increase training, capacity building of our people. And I think you, as a legal practitioner, do you know about policy at ECOWAS? You know that at ECOWAS you have the journal of ECOWAS, where you can get everything. We would like from chambers of commerce work with you, set up a technical working group, cascade all this law in what private sector can use at the border. I cannot read a Bible like you, but if you give me 1 page to do my business, I will be happy. So thank you very much for this. My sister, she putting pressure on me. So thank you for listening to us. I think that the discussion is open. We will continue to address this issue. Thank you.
Thank you very much, gentlemen. Thank you. I'm sorry I was breathing down your necks, but we are completely out of time. Please, can I invite the Secretary General of the ILA Nigeria branch, Mr. Clement Osuya, to please do us the honors of thanking our guests. Thank you so much. Please, let's do this quickly. Madam Chair, please join them for the photographs too.
Okay. Thank you so much, Professor Taufik Landan. You have always delivered. We are very grateful. And I also want to thank our moderator. Okay. Thank you so much for coordinating this section. It's so outstanding, and I'm sure the participants has acquired a lot of knowledge. We thank Ambassador. You're giving me the wrong information. Okay. We want to thank every other speaker, and we are very grateful. On behalf of the President of the ILA, Professor Damilola Olaoyi, Senior Advocate of Nigeria, and the Executive Council members of the ILA, we say thank you so much. And I want a round of applause for... A round of applause, please. Yeah, thank you so much. So at this point, the section is over, right? Okay. Okay, so we have a gift from the... We have a gift from, on behalf of the President. We are presenting this to you, saying thank you so much for honoring our invite and giving such erudite lecture to the participant. Thank you so much. Thank you.
Thank you very much. Nobody said. Thank you. Please, there's a Honda Accord car with the plate number RBC 496GG. Please, we need you outside. You're needed outside to repark. If you are the owner of a Honda Accord RBC 496GG, please kindly go outside to repark. Thank you very much. Straight away, we're going to move to our next panel session. We're just going to quickly take the panels, which will be after, so we're reordering our program. And so we're going to go on to plenary panel 3. I have the pleasure of bringing up the moderator for this panel, Professor Emiri Festus, Senior Advocate of Nigeria. He is Chair, Nigerian Bar Association Institute for Continuing Legal Education, MBA ICLE. Please welcome him. Thank you, Prof. Also on this panel is Professor Jiaru from China University of Political Science and Law, Beijing, China. Thank you, Prof. Also on this panel is the Director of the World Intellectual Property Organization, Nigerian Office, Dr. Tobiloba Moody. Is Doc in the room? Thank you, Doc. Please join us on stage. Also on this panel is the Assistant Director, Head FDE at Nigerian Revenue Service, Member National Working Group on Illicit Financial Flows, Adeyemi Aladeshawe. Please give him a round of applause. Thank you, Dr. Moody. Thank you, Mr. Aladeshawe. Senior Partner, Goodshare and Maxwell, Mr. Stanley Maxwell, eBay. Please don't get tired of clapping, please. Thank you. We also have the HOD, Public International Law, Veritas University of Nigeria, Abuja, Professor Victor Odweme. Is Prof here? Thank you, Prof. And last but not least is the Deputy Director Legal FCDA, Adeku Innocent Anuku. Thank you very much, sir. Do we have enough seats? Can we get one more seat? Quickly, please, can we get one more seat? I'm sorry, Mr. Anuku, someone is bringing a seat. Thank you. Prof, can I have you move your seat a bit so that we can accommodate one more seat? Thank you, sir. Thank you, Prof. Thank you very much.
So I'll just, very well, I'll try as much as we can to ensure that our program runs speedily. I'll just do an introduction. Do I really need to do introductions? Yes, I will. So we have just on my right, Professor Jiaru is from China University in Political Science and Law in Beijing. And thereafter we have Dr. Tobiloba Moody. Tobiloba Moody is a director the World Intellectual Property Organization in Nigeria office. Very well. Then thereafter him we have Adeyemi Aladeshawe. He's the Assistant Director, Head of Nigeria Revenue Services, And we have Maxwell Ebay. He's a senior partner with Goodshare and Maxwell. And we have Professor Dueme, and after Professor Dueme, who is the head of public international law in Veritas University. Then we have Innocent Anuku, who is a deputy director, legal Federal Capital Territory. This is going to be an interesting session because we're going to be looking at how we could really put in place laws that would enforce, that could help reduce, as it were, if not eliminate corruption. So I'll try as much as I can. It's a very wide panel. We'll try and ensure that we just send a few questions to them and they will directly answer so that all of us can benefit. My name is Festus Emiri. So I think I'll start with you very well. I have already a question which is designed for you, and my question to you is, well, we're talking about international cooperation. It has remained a veritable tool for combating economic crimes. From your own perspective in China, what do you say are the key challenges in harnessing and harmonizing legal framework across the jurisdictions in combating illicit flow of funds? What would you say?
Yes, thank you, Professor. So it's really my great pleasure to be here. So I just came here through by airplane. It was take 20 hours from Beijing to Abuja. And I took my body here. So I hope my language, especially English, that's a little bit awkward. So it can transfer my idea safely to you. So about this question, when we talk about the harmonizing legal framework, I think I can frame a mental picture. So a person in country A, he uses his laptop to move stolen money through a share company in country B and to buy an apartment in country C. So this is one simple example, but it can show how hard the challenges we face. For country A, the people they have their own way to define crime. For country B, they even don't know who is the real human being behind the share company. For country C, he just sees a foreigner buying an apartment and paying taxes. So here, behind this example, I think we can see three challenges. The first one is speed gap, because money moves instantly. But the request to forward money to country C before it comes to the central authority, it needs to be translated, need to be notarized, and maybe wait for months before this document sits in someone's office desk in foreign capital. So I think this can show the challenges we face. The crime is committed. That's a 21st century crime. But the treaty we use, that's of the 20th century. So the second challenge is information black hole. For country B, they don't even know who is the real owner of this sharing company. Even they want to help, they cannot. So when they request to country C, they want the help. When the requests arrive, but actually they cannot provide the feedback. The third challenge is, I think it's about, The third is about the priority mismatch. For country C, they just care about a foreigner buying apartment and the foreigner pay taxes. But country A, they treat the crime very critical because the crime drains the national budget. So for different countries, they have the different priority of their work. So that's a challenges. So this more of a problem of the will to control the crime. It's not just law issues. So given this messy reality, there are three concrete fixes. The first one, mandate automatic information exchange. So stop relying on request. International law should require all states to share beneficial ownership registers. So when country A get a notice, his citizen has used share company in country B and buy apartment in country C. He just received this notice, so he knows that they don't need to wait. So because the data arrives. So the second fix is legalize direct practitioner contract. Treaties connect states, but the investigator in country A, they have to contact the investigator, detective in country C. But according to the current international law, they contact each other through layers of the bureaucracy. So if we can build judges to judges and detective to detective communication, that will be very helpful to control the international economic crime. The third is enforcement, no safe haven, because principle is simple. Extradite or prosecute. If country C won't send the fugitive back, it must put them on trial itself. So this removes the incentive to harbor economic criminals.
Thank you very much, Prof. That is interesting. So some states have different bases for which they want to fight crime, whether they want to fight or not. Some actually want the funds, from what you've just told us. Well, thank you so much. We'll come back to you because you're still going to profile for our solution. Now, you know that today, intellectual property is also becoming another basis for which people can spirit monies away from jurisdiction. So let's hear from Modi what he thinks international law can help us do in combating this and also unveiling them so that at least they become open, more open, and then you can then track them. So tell us something about it.
Thank you very much, and good afternoon, everyone. I think I'll just very briefly just highlight a few points. And as you rightly said, intellectual property crimes, or like the theft of intellectual property, is also a huge vehicle for, I would say, like a lot of illicit financial flows. We're seeing that, in the world of intellectual property, when you deal with a counterfeit good, that's really considered, that's when we talk about the crimes, right? So we know that even around the whole TRIPS agreement and the foundational multilateral trading system, a big push for having the TRIPS in the covered agreements was really around counterfeit goods going across the world, and that really informed why a lot of countries pushed to have that agreement in the covered agreements of the WTO. Now, but then you see that even today, we still have a lot of trade in counterfeit goods going across the borders. I think OECD's latest report estimates close to $500 billion annually of trade in counterfeit and pirated goods that are going across the border. And bear in mind that this does not include pirated goods that are being sold within countries. Now, this is just focused on the goods that are being transported, exported across countries. The other part that is not captured in the OECD report is digital piracy, and which is now in our time probably more significant even than the trade in goods, counterfeit goods. And IP is at the heart of it. So whether you're thinking about trademark, patents, really it's about how to address this issue of counterfeit goods. Now, I think just to say briefly about what we see from WIPO's perspective is that one of the key factors is about, we have a section in our organization that focuses on building respect for IP. And it's really about how do we strengthen enforcement mechanisms around IP. One of the big challenges we find is that many countries, of course, a lot of people are not aware. When you look at where the exports is coming from, a lot of citizens are not aware. People don't believe that they're committing crimes. So they just feel like it's something they're doing, but the sense of this is also a criminal activity is very low. And so there's been a lot of investment by a number of countries to really promote that. And we see that even in Nigeria. The Copyright Commission in the latest act that has been released has powers to arrest, to detain. I mean, and that's something is consistent with how many other countries have approached this. I think another thing that we've been working to do is to work a lot closely with custom officials. We find that a lot of times they're not always captured in the training and the awareness programs. And so we're working more with the judges, with the border officials, the police officers, Interpol, again, to really help to track and to ensure that we're able to prevent, to as much as possible, the movement of counterfeit goods. And I think the last thing I just want to say in terms of the work that we're doing is also to really strengthen, to develop strategies. And so in Nigeria, for example, we're working with the government to, and this is on the issue of digital piracy, we're working with the government to roll out a particular project that's helping to develop strategies and tools that are unique to Nigeria. Now, what we've seen is that a lot of countries on this issue of digital piracy are struggling because of the lack of coordination, and this is where international law, I think, plays such a strong role across countries in tracking sites where these things are happening. And so even when it's identified, most times you still need the collaboration or cooperation of the host governments, right, to be able to effectively block sites and the likes. And so we've been working with several countries, and Nigeria and Ghana are currently working with us to develop a unique project around strategies and tools to really effectively address this in this context. And so I'll pause there, but just to say that it's really a big problem, and international law plays a critical role in that.
Thank you very much, Dr. Modi. But I'll ask you a question. How would you link counterfeit goods to IFF? How do you link them?
Well,
so that we all can understand you properly.
So, I mean, if you look at the counterfeit now, what happens is that when you have counterfeit goods...
Yeah, explain to the audience.
Okay, just so that people understand, it's when we're linking it to IFF, you're looking at where the money is going. And we find that a lot of clandestine operations, when you look at counterfeit goods, some of the sectors that we see most prevalent are dangerous goods, things like pharmaceuticals. And you also see in areas, I'd say that high on the list is also things like luxury goods, but let me use pharmaceuticals as a case in point. Now, organized crime centers around a lot of these operations, and so people guard it jealously. And you see that when the Copyright Commission even goes out, and I'm using an example of copyright, when they go out to intercept illegal shipments, the officials are often at risk of even being killed on such raids. But then it means that there's also a sponsoring. I mean, when you look at where that money is going to, it's actually going into strengthening and promoting illicit crimes. And so I think just to say that there is a strong connection between these thriving counterfeit industries, as I'll call it, and also the financial flows. I just wanted to make that connection there.
Thank you very much. I think we now understand the connection better. I do now. Now, thank you so much for that contribution. We will now take on Adeyemi, who works with the National Working Group on IFF. We would like you to tell us exactly what are some strategies you've put in place and things you're doing to prevent illegal flow of funds. Thank you very much, Mr. Moderator. Good afternoon, audience, and my fellow panelists. At the committee level, we meet periodically, and we have been able to do a lot in terms of trying to estimate, get the right estimation of illicit financial flows in order to mitigate risk assessments and then to ensure that we combat illicit financial flows appropriately and most effectively. On that committee, we have most relevant agencies, and from the immediate the last speaker, I think there's need to actually collaborate with Copyright Commission. I've learned a lot from what he has said. So there are relevant agencies like the Nigerian Customs, Nigeria Immigration Service and all that. What we have found is that there is need for political will and then to have an integration of, to continue to share data, interagency relationship, and to develop strategies towards combating this. In the NRS, we have a dedicated unit for automatic exchange of information that enables us to exchange information with some other countries of the world. And we have done that. We have exchanged over 160 countries. We have their data, and they also have ours. We also have this CRS and then CBCR. You know, these are country by country reporting, and these are mandated by the BEPS reports. There are disclosures, mandatory disclosures that has to be done. FRS, Nigeria, under the auspices of NRS, has keyed into most of this, and we are implementing these strategies to ensure that we combat IFFs effectively. Apart from the AOI unit, we also have the transfer pricing unit and the international tax unit. Under the new reforms, we have been able to strengthen our laws to ensure that we capture, we tax, we go after illicit monies, because taxation does not really frown at illicit monies, so to say. we go after you, we tax you. But under the POCA, Process of Crime Management Act, FRS, FRS, now NRS, is a member, is one of the relevant key stakeholders that is mentioned in that act. That makes us a law enforcement agent. And that ensures that we have to do what is assess and value risk recovery, value-based recoveries. So what I mean by that, the conventional raise assessments, investigate, audit, and come out with taxes, interest, and penalties for taxpayers. In addition to that, we are now allowed under the POCA to go after that, and then instead of get that little interest of 31% on the principal tax that is owed, or in addition to the interest of 10%, penalty of 10%, we can assess the value of that asset that has either been stolen or used for illicit activity, and then probably recover the asset and still for tax purposes also. So this is a double sword approach which has been there. We have operationalized the POCA, and then for want of time, let me just quickly say that there's need for a whole lot of there's an experience that I had. A colleague that knows my background with the Ministry of Justice was trying to get some information around some treaties that was documented, whether it has been domesticated. It's an agreement between Canada and Nigeria
for offenders, repatriation of offenders. And I got across to my former colleagues, and behold, it took almost forever. What is going on? I sent messages, I called, and at the end of the day, they didn't have answers. I know that we have the Federal Ministry of Justice is mandated by the Constitution to archive domesticated, but are we even getting it right by this? So these are some of the areas that we need to look at to further strengthen our legal frameworks. Archiving, proper archiving, and then finally, there's a multilateral instrument, which is the Action 15 of the BEPS report, OECD BEPS report. This instrument has been lying with the National Assembly since 2017. Only God knows what has, and we are losing a lot. We are talking about treaty abuses, which facilitates, is a major enabler of IFFs. And once this single instrument is domesticated in our laws, we are able to bring up to date all our domestic and DTAs, democratization agreements, just swiftly, without having to amend each and every one of them, and then to operationalize the 15 BEPS actions that has to do with transfer pricing, which are major illicit enablers. So we'll require help of NILD to help facilitate that. Thank you.
Go to eBay, who is a private legal practitioner. We know that lawyers, whether you want to accept it or not, are known to be enablers of corruption. That's the truth about it. Yes, law firms and lawyers, if you look at most transactions, in fact, if you look at most of the international money laundering cases, Republic of Haiti and Dovile, those who help them hide their funds are lawyers. So I have actually written a paper on against confidentiality. That's the title of that paper. I think it was published by Niles. So tell us exactly, what can lawyers do to help prevent, fight, disclose illicit funds and not help as enablers of corruption?
Okay, so good afternoon. Since you mentioned Duvalier, I thought it would be useful to touch a bit on it. So Duvalier was president of Haiti from 1971 to about 1986. And the government of Haiti essentially said he stole, together with his wife and cronies, about $120 million. So what they did was in 86, they filed a case in France where he was living, essentially requiring him to return the money that he allegedly stole. And they did something else that I found very interesting. They went to England to file a case requiring the English court to restrain Duvalier and his family and cronies from dissipating the assets wherever they are. Now, what's interesting about that is that the UK court, up to the Court of Appeal, actually granted that. And they did that on the basis of the Brussels Convention. And essentially, that takes me to the point about how international law intersects with national law. Now, the case was successful in England, partly because England actually ratified that Brussels Convention. But not only did they ratify the convention, they domesticated, and they took essentially the next step to apply the principles in that convention. The challenge, and one of the points you make about confidentiality was actually raised in that case. And the court said, come on, we have an obligation to essentially, the Brussels Convention creates an obligation on states to do in their states what would have been done in other states. So if you have assets wherever they are, the court in England can say, don't touch these assets. And, the court also said, look, lawyers, you've got to disclose assets of your client that you are aware of. Now, if you are going to deal with the scale of corruption, the scale of IFF we have on the continent, you've got to start thinking in that way. Unfortunately for us, like Dr. Ladan said, we don't take treaties very seriously. And I give you one example. So Nigeria has ratified the protocol to the African Charter on the establishment of the African Court of Human and People's Rights. We did that, but under that protocol, we are required to make an Article 34.6 declaration, essentially enabling NGOs and private individuals access to the court. Nigeria hasn't done that. Just last week at, I believe it was Bayes University, the Nigerian judge on the African Court of Human and People's Rights was here to have a conversation on the 20th anniversary of the African Court. We have a judge there. The court is based in Arusha. We have ratified the treaty. We are not willing to allow NGOs and individuals access to the court. What's interesting about that is about 90% of the cases that have been decided in the African Commission were done by NGOs and individuals. For obvious reasons, states don't proceed against each other. There are only 2 cases that have come to the African court, essentially, by states. One of them, or 2 of them actually, were referred from the commission itself, not by states. So, I mean, the example from the Duvelia case seems to me we've got to try and find a way to use those kinds of, for want of a better word, harsh measures to get to people who just steal the commonwealth of their countries.
Thank you very much. In fact, I'm of the view that the African continent should look at the Brussels Convention and sponsor one as an international convention. Because the truth about it is that Duvelia case, for those of you who read injunctions and things like that, an injunction must be tied to a claim. But that particular convention makes it possible for an injunction to be an only and final remedy. So our judges need to begin to think through things. So if you sue a person whom you think has money, who has stolen money from Nigeria, and the money is somewhere in Ghana, you don't have to have a claim against him in Nigeria. You just bring a claim for injunction against him, arrest his assets. And once the man's assets are arrested, of course, the man is on his knees. He can't pay lawyers. He can't do any other thing. The man would negotiate. Is that not true? That's the kind of thing we should begin to think about. So let's go. Thank you very much, Max, for telling us that. Let's go to Udweme now. Udweme, you're now going to let us see how we can better use international law to fight corruption and enthrone some level of transparency, especially for the African continent.
Thank you, Mr. Moderator, and friends on the other side. I think the first thing that we must understand when we're looking at the issue of having international law, come to our aid in this regard is that international law, on the first instance, supports that states, help each other. The meaning that no state will be, entirely on its own. None lives in a state of autarky. No, but the danger is that international law is in a state of flux. Laying credence to the recurrent question whether international law is actually law at all. Now, what I think we should do is that we should look at international law again about, the composite element of morality. I'm particular about this morality element because I know that law and morality are almost on opposing ends. And of course, I think it was somewhere in the Bible that is written that if there are no laws, then there will be no sins. So if we're talking about this law stuff and then financial flows and illicit interactions are on the increase, I think we should begin to look beyond the laws itself. And I think what international law should be doing at this point is to, although I think it's above the remit of international law, it might just be with national laws. But an international law can lay the foundation like it has laid in so many other places like issues of climate change and the rest of them. If you look at countries like Japan, the incidence of IFCs are not that endemic. And that calls to mind that there is a culture of excellence, a culture of accountability, which I think that international law should promote, and national law should latch onto it. If we institutionalize accountability, it becomes difficult for these monies to start flowing in the first instance, because much of the finances that get themselves accumulated and have to be exported are gotten from public coffers, not from private coffers. So why don't we start from the beginning, go back to the basis and make sure there's a culture of accountability or institutionalization of accountability. Look at our public officers in Nigeria, for instance. Somebody becomes a minister and the next day he's charged for, I think, let me just remember one. I think it was one Inspector General of Police that was leaving and had so much money than the police had. How did he, I think it was Inspector of Police Balogun also. How did he amass that level of money? Whereas he's the chief executive of the police, then there's somebody in charge of finance. And there are people who know where those monies were coming from. The budgets were made, monies were released. They were tied to certain items that were not, budget lines that were not executed. And the money didn't fly by itself. Somebody moved it from one point to the other. I think that we should go beyond the remit of having, laws like someone has suggested earlier. We should start looking at consolidation. Part of that consolidation is that international law should also try to bring in some level of morality into it and institutionalize accountability, so that it's easier for you to do that at that point, because the persons who handle international law are not exactly directly involved in these IFCs that we're talking about. It's national governments that actually promote them. Most of them who have access to these monies that flow around have government protections or have access to government coffers where they can leave these monies without a trace. That's my little contribution at this point.
Thank you very much, Professor Duane. We will now go to our brother Nuku, who is with the Federal Capital Development Authority. Today we heard from this platform here that about 10 trillion naira or so are sunk into building projects, all part of linked to money laundering and to corruption. What can you do in the FCDA so that you're not regulatory captured, but you can actually regulate and fight corruption? What do you think you can do in a place like the FCDA, in a property department, so that we can bring to nails those who keep properties and cannot really say how this money is gotten and the buildings are put up? Is there a way the FCDA can do something for us? Because we're talking about agencies, regulators now, all helping to fight corruption. What do you think the FCDA can do in this respect?
Okay, thank you very much, moderator and distinguished panelists. The issue of corruption still remains a cankerworm, not just in our country, but even in other climes. Talking about property, for some years now, even within the Federal Capital Territory, you discover that there are buildings, massive structures erected, and then for several years, you don't see anybody inhabiting those houses. So the pertinent question that will arise is, would a genuine investor with legally acquired funds sink in his money to build structures like that, and then no tenant is living there, the buildings are not being utilized, and they are just there? So for the Federal Capital Development Authority, it became an issue, and we said definitely these buildings were not legitimately acquired. Investigations must be carried out to
to know the source of the funds and all that. And you know, that also brings the issue of interagency collaboration and all that. You know, from our collaboration with the Corporate Affairs Commission, you know, and other sister agencies, we discovered that yes, these are proceeds of corruption, and some of the steps we have taken and which we continue to take include the revocation of some of the titles involved, and then also using the NFIU and other law enforcement agencies to track the source of funds so that the persons involved would be made to face the full wrath of the law, which includes proper investigation and prosecution. So to some extent, you know, these steps have been taken, and then even as we are taking these steps, we are not also shying away from the fact that we have internal collaborators within the system. So for the public service, we are all aware that there are, you know, self-regulatory frameworks to ensure that public servants, you know, do not collaborate with those that, you know, are making the country dry. So we have, you know, regulations like the financial regulations. We have the public service rules, which are very comprehensive, you know, in dealing with, you know, some of our public servants who get themselves involved in some of these vices. Then we, like I said earlier, we are collaborating seriously with the Corporate Affairs Commission, just like it was mentioned in the earlier session, that most of these properties that are acquired, you know, they normally use companies. They don't use their individual names. So like at the Abuja Geographic Information System, we try as much as possible, you know, in the process of allocation and the process of maybe registration of deed of assignment and other processes, to make sure that our KYC is comprehensive enough. You know, we request for detailed, you know, documents from the Corporate Affairs Commission so that we will know who are the directors, who are the shareholders, and we also request for board resolutions and all that at every point in time so that we'll be able to relate some of these things to the relevant law enforcement agencies. So by and large, when we talk about investment in the country, promoting investment in the country, these are some of the things that potential investors will want to look at. How conducive is the investment climate in Nigeria? And Abuja, being the federal capital territory, is very fundamental. So I will say that we are making efforts, and such efforts are yielding fruits. Thank you very much.
Thank you, sir.
I think we should clap for that. I know that recently the UK government did a property audit, and I know that there was this particular Nigerian who was said to own 17 houses. In fact, I was surprised. I know him. So I think we need a kind of thing like that. And these are some of the things regulators can do. That way you can show that you're really fighting corruption. I think we need to be more innovative. So we are pressed for time, and I'm going to apply what those of us in philosophy call the Occam razor, that entitlements must not be multiplied if one will do. So rather than ask them 2 questions, I have only asked one. I will just ask that they do a 1-minute summary, and when they finish a 1-minute summary, we can then take questions. I hear that we're short for time. Who would like to take the first 1-minute summary? Very well. So please give the microphone to Dweme.
Yeah, thank you. I think
You know, the questions maybe
with solutions now. We want solutions.
Yeah. So the solutions I'm looking at now is that we should consider having asset registers that are open to the public. We should consider having asset registers that are open to the public. You don't need any serious procedure to have access to them. You know, then there's need for countries to start denying access. You know, monies are stolen from Nigeria. The next time you see they are buying houses in the UK and all of those things, they know that where those monies are coming from. When they finish enjoying the process, they will now claim that, oh, you brought money here and they want to return it to you. If at all, they tell us exactly how much is out there. Now, I've mentioned the issue of morality. We should begin to consider that at every point. Then the other thing I want to draw attention to is that international investment schemes, you know, there should be a regulation for international investment schemes, but you find out that that's actually a conduit for money laundering. Let me end it at that point. Thank you.
Thank you very much for telling us those wonderful recommendations. Yes, Maxwell, you want to tell us something, maybe? What would you recommend? Well, we're looking at solutions now.
Yeah, I mean, international law is great, but only to the extent that is actually implemented. So there's no use. I mean, one of the things I did last year was to try and find out if there's a record. I think somebody raised that on this panel, of all the treaties, human rights treaties we've ratified as a country, and the extent to which we have implemented those treaties. I hope Professor Ladan can tell us something about that. But I tell you another treaty. The Malabo Protocol is a 2014 treaty that essentially creates an additional panel for the future African Court of Justice and Human Rights. Now, what's interesting about the Malabo Protocol is that it recognizes money laundering and corruption as crimes that will be dealt with under that panel. 10 years after, we only have one state, Angola, ratifying in 2024. One state. You need 15 states for that protocol to become operational. Only one has ratified. Now, there's a background to that. In 2024, when the protocol was going to be signed, African states were saying no to the ICC. We don't want to have anything. The ICC was designed for us. And there's some merit in that argument. We will now create our own international court on the continent. But 10 years after, only one state has followed up with a ratification. That tells you everything you need to know about Africa and international justice.
Thank you for letting us remember that again. Adeyemi, I think you'll now round up for us in another 1 minute.
As lawyers, we're said to be gatekeepers. We see the system from start to finish. Panama leak, which is one of the greatest leak of illicit flows in the world, had lawyers, Franca Fort's law firm, you know, at the center of this. So due diligence, very key. In Kenya, PALU, Pan-African Law Union, was able to team up with Tax Justice Network to stop an obnoxious double taxation agreements that the country had signed into being ratified. In that, treaty abuse is a major enabler of IFFs. Mauritius had put obnoxious clauses in that agreement such that we will not be taxing capital gains tax and some other taxes. And the lawyers stood up and said, no, this law, this international treaty will not on the soil of our country. And they went to court and it was stopped. South Africa took a cue from that. They ratified quickly. Nigeria was at the verge of ratifying. We stopped the ratification of that treaty. Mauritius, Nigeria treaty, South Africa was revised, and then the Kenya was stopped completely from being ratified. So the lawyers have And just like my friend has said, that morality, justice, fairness is beginning, transparency is taking the center stage. The way we know tax, the way we know law, is that morality, justice, but in the 21st century, we have come to the hard realization that these principles must guide us going forward. We pride ourselves as ministers in the temple of justice, so there's a lot for us as lawyers, as professionals, accountants, tax auditors, and all that. Thank you.
Thank you very much. Moody will now tell us what we can do with intellectual property. What are his final recommendations?
All right, thank you very much. I think maybe just to say that my suggestion would be that first is, given the nature of intellectual property and the intangible nature of the assets that we're dealing with, I think it's important to emphasize greater cooperation across countries. And I think this is something that, of course, we know that acceding to treaties and all that is important. But I think when you also look at how countries are cooperating and designing strategies to track protection, harmonizing such structures, I think it's really going to be an important way forward. I think also just a point that we've seen in Nigeria recently is that the national IP policy and strategy was launched. And what it's really done in one way is to also strengthen internal coordination across agencies and units that are working on, tracking and preventing such things around IP, counterfeiting of IP and piracy generally. And so I think that's another thing. And the final point I wanted to make is just, again, to the lawyers, and I say this because of what we do every day, it's just that we need to raise the level of awareness around intellectual property. Please, more people need to know, more people need to understand, and whether it's you taking the time to go to a secondary school or go to a university where you finished from, but just to please let people know about intellectual property. The real wealth is moving in that direction, and we're going to see a lot of that money going into the wrong places, going untracked, if we don't see that picture from now. Thank you.
Thank you very much. We'll now go to Charis, a man from Beijing. You want to tell us a few things, a roundup?
Yeah, because in the past decades, China faces the fast growing in economics, but also the growth in corruption. So the lessons I think I conclude as if we're fighting international crime, the partners should be act not on papers but on trust between friends. The international community should be a team, just like that in China, because the China government fighting against the economic crime, it's not just a matter of police. That's integration of our agencies of the government. If dirty money moves, so the police will know that. But also the Ministry of the Immigration, the Financial Intelligence, the Foreign Exchange Department, all know that. So all Chinese agencies act as a single task force, not just police office. So my conclusion, fighting against international economic crime, partners should be based not only in treaties on paper, but based on the trust between friends. We have a team at home. So in the future, all of us should have a team internationally.
Thank you very much for giving us that perspective. My own contribution would just be that we should begin to bridge the gap between international law and private law. I know that one of the things I learned in the criminal law is that principal offenders are not just the ones who do the act. Those who enable an act are also said to be principal offenders. Is that also? There is this principle in private law that says that those who aid a person to steal, because when you steal, that money, of course, is stuck with some form of fiduciary. Those who aid the fiduciary are knowing receivers or knowing assistants. And I think we need to begin to look at some of these principles in our local courts. So our judges can begin to understand those principles, that where monies are fiduciaries, monies that are stolen or transferred or some other thing, those who aid that, and in fact there are levels of knowledge and notice that are required, they also are also persons you go against. So rather than sometimes pursue the criminal, you just pursue the bank that was used basically for it. We could look at one English case I remember, I used to talk about it, Lipkin, Gormack, and Capnell. That's one interesting case that showed that you can continue to follow and trace money even in the hands of a person who is not the thief, but the hand of a person who has received, or the hand of a person who actually aids and assists. So some of these things, we need to begin to look at them, incorporate them in international law, and like we talked about the Brussels Convention, Africa should sponsor something that looks like the Brussels Convention, which of course the Malabo thing is actually in an embryonic way of seeing it. So when we begin to do some of these things, we can begin to fight criminals. The fight, like we just heard, is a marathon, it's not a sprint, it's not 100 meters yard. So we'll take a few questions that we're mindful of our time so that we would have the panelists answer them. My friend at the end, Amuko, hasn't made a conclusion, I'm sure. Most of the questions he would answer. So please put your ears down. Yes, first, Ladan, please. Yes. Can you use this? 2, let's take a lady. And Madam 3.
Thank you very much, MC, and congrats to our panelists. Mine are not questions. I just trying to provide some clarifications. First, the third speaker, Adeyemi, just a minor correction. The Constitution of Nigeria did not mandate Federal Ministry of Justice to establish an aside depository of treaties. It is rather Cap T20, not of the Constitution of Nigeria, that provided that mandate. It obligated the Federal Ministry of Justice to establish a national depository of treaties, so not the Constitution. That's minor correction there. But I understand your concern, and I think as we speak, the depository was publicly launched, but frankly speaking, the MDAs in Nigeria, they are not feeding the depository with the BITs that they have actually championed, on behalf of Nigeria. So you can see where the problem also lies. So I think that's where I share your concern, in that context. And I'm linking it to Stanley Ibe's something, and truly speaking, in 2024, when I was DG of NIAS, we actually we tracked and documented all the number of treaties signed by Nigeria in the area of environment, human rights, IHL, IPR, trade, investment, and the ones, ratified, yet to be domesticated, and the ones that have been domesticated, and the ones that are pending. And then we published it in a book and took it to the Attorney General's office and shared with them. It is titled Treaty Law and State Practice in Nigeria. So we've done the documentation for them. It's up to them for them to actually, upscale it from there. But I think as we speak, Stanley is very correct. Over 95% of multilateral treaties, not BITs, of multilateral treaties that have been signed by Nigeria, have not been ratified. Over 80% of the ratified, multilateral treaties, not BITs, that have been signed and ratified, have not been domesticated. So this requires, moving forward, Mr. Chairman, it requires, we notice that there is actually a gap in terms of executive-legislature relationship. So if there is that policy dialogue gap between these two institutions, they can never actually work, and they will never understand how to even prepare a work plan to prioritize discharging Nigeria's treaty obligations under international law. That is one of the biggest problems that we're having as we speak in practice, not theory. Finally, Mr. Chairman, and I think I would also like to say that Dr. Modi actually rightly, gave that recommendation in terms of the need for greater cooperation and the reason actually the level of awareness. I think it applies not only to IPR, but I understand where it's coming from because you champion IPR. Truly speaking, multilateral treaties have always received very, very low awareness raising in Nigeria. The CSOs, CSOs have been doing their best, but it is simply, supplementary, and it's not enough. Thank you very much.
Okay, thank you so much. First and foremost, my intervention is in the area of the comments that have been made, actually touching on the idea of domestication of treaties, particularly in this subject matter, not generally. But before that, I have a response to the opinion of our big brother, Mr. Adeyemi, who said that tax does not necessarily frown at illicit funds. I would want to say that tax should not even be targeted at illicit funds. It's only legitimate process that should be taxed. That's what I would say. Illicit funds are to be forfeited, not even taxed. You take the whole thing. That's what the Process of Crimes Act says. Because tax evasion is a crime and is a predicate offense of money laundering. So that is a basis to forfeit any asset that has been tainted with tax evasion. So you should not even talk about taxing it. You should take the whole thing. That's where I want to stand if you want to be serious in fighting this monster. Now, going further into the issue of domestication of treaties, I want to talk about the mandate of justice, not that only pray for justice. But having worked in environment and have a background in international cooperation in criminal matters, Central Authority units specifically, most of the treaties having to do with international cooperation in criminal matters have been domesticated to the best knowledge that I know. For instance, we have this tradition. We have Extradition Act. We have Mutual Legal Assistance Act. We have Transfer of State Offenders Act as well. And all these are very useful in battling, transnational crimes. Now, the idea of strengthening this international law is in the effective implementation and enforcement. But beyond that, even those treaties as we see them today are almost outdated. Yes, I'm with you, sir. Because I would have to say this, sir, if you are invited people of justice from that department, it's very important. International cooperation round up. That's what we're saying. Thank you, sir. So, what I'm trying to say is that for some of the treaties that have been domesticated, even the UNCTAD we talked about so much, there are a lot of lapses. For instance, ABCA is like made for Europe, Eurocentrism. It will not carry along traditional institution of law enforcement. Our traditional rulers, our churches are very religious. These are where money have been laundered through churches, even communities who are thieves. But UNCTAD is talking about former inspector of police alone. So Africa has to also think of the kind of convention that would take into consideration its own peculiarity, its own traditional agency of fighting corruption. Before the Western man came, we had our own ways. Can we carry this process along to make sure we strengthen this and take it forward in fighting this global menace? Thank you so much.
Thank you very much.
I want to lend my voice to the voices of those who have already spoken to appreciate the panelists. My name is Dr. Anita Nwotite. I'm a senior lecturer at the Faculty of Law, the Azikiwe University, and the adjunct lecturer at Shanahan University. I'm here at the instance of Shanahan University, Onitsha. My question is this, and it's directed to the first panelist, the representative from Beijing. So my question is, how can China cooperate with African states like Nigeria in combating illicit financial flows, particularly with respect to information sharing and asset recovery? How can China cooperate with Nigeria in that regard? Thank you very much.
So please you permit me to ask Dr. Nuku to respond on our behalf. And after that, Professor Jari would speak. Madam's own and the other one. Just round up.
Well, the question was directed at our brother from China, but based on the directive from the moderator, you know, I'm a civil servant.
Leave the China one for the Chinese.
No, I think Prof made very good interventions concerning okay, the China this thing. Okay.
Okay, let Professor.
But before the China question, I don't think there was any question. Yes, there were just observations made by the audience. Okay. For my final word, I will just want to emphasize the fact that economic and financial crimes have assumed global dimension, and the response must also be global. So, and from the context of Nigeria, I would want a situation whereby we would invest more in our law enforcement agencies. Technology, is very, very key. Our law enforcement agencies need to be fully equipped because the nature of some of these economic crimes have taken, the dimension that we cannot use, what we are used to in investigating and, prosecuting them. So we really need to invest more in our law enforcement agencies to aid them adequately in carrying out investigations. And then for the criminal justice system too, we really need to address especially some of the challenges faced by the judiciary, whereby, these days we talk about perpetual adjournments and then judgments that take quite long to be written, and then the time it takes for the appellate process to be exhausted. So it's something that we really need to address because they contribute, to a great deal in ensuring that we have a conducive business climate and in also combating, illicit financial flows. Thank you.
To this question, I think global cross-border economic crime is global issues. It's enemy for all human beings. So when we fighting against these economic crimes, so all people in the globe are friends. So I just concluded just now from China's experience. Domestically, all agencies work together as a single task force, work as a team. So globally, when we fight against the crime, we should also build the same team internationally. So that's a perspective of the human beings. Second, I think the crimes, we should focus we should build a long-term and permanent optional working group together. It's more important than paperwork. It's more important than just signing agreements, because international treaty is always very abstract. So it needs to be elaborate and need to be improved by the legal group. So if we have a permanent working group together, so that will be very helpful to make the law, the treaty into practice. So third, I think information sharing is important. Technology is important. because AI, the big data that empower all legal practitioners to put the law into practice. So, I just mentioned this big gap. In Chinese saying, we always say the devil grows 1 feet, the justice grows 10 feet. But today, the reverse, because AI runs so fast. We always say AI 1 day, human beings 1 year. So in this time, the trust is even important. The confidence in cooperation is even important.
Thank you very much. So I thank all the panelists for doing a great job. Thank you, Professor, for coming from China. Thank you, Modi. Thank you, Adeyemi. Thank you, Maxwell. Thank you, Professor Dueme. Thank you, Amuku. I think this will be the end of what we want to do here. You discharge us. Thank you very much.
And thank you, our moderator. Very well done. Please, can I have the Secretary General of the ILA to do the honors and present gifts to our panelists?
Yes. Hello. Let us seek the former Honorable Attorney General of the Federation. We want to formally welcome you, sir. We want to formally welcome you, sir. Yes. So let's give a round of applause and a welcome applause to the former Attorney General of the Federation, Mohammed Bello Adoke, CFRO, Senior Advocate of Nigeria. Thank you so much, sir. Thank you so much, sir. So we, on behalf of the President of the ILA and the entire members of the ILA, we are presenting this gift to you to say thank you so much for honoring our invite. Thank you so much. Thank you so much, Prof. Thank you so much. Thank you so much. Thank you so much, Doctor. Prof, thank you. Thank you so much. The great moderator, thank you so much. We appreciate you. So let's have a group photograph.
I'm always the only one.
Okay, so we're going to go straight away to the breakout session. For those interested in the first breakout session, you go to hall 2, which is just down the hall. You see someone outside to direct you. And for those interested in session B, you stay right here. The breakout sessions will just be for 1 hour each. I've also been told that the Honda Accord RBC 496GG cream color is still outside. Please help us go and repark. Honda Accord RBC 496GG. We'll go for our plenary session now. The plenary sessions will end at 5, after which we'll then meet for lunch. Thank you very much. If you are interested in session 1A, you go to hall 2. You'll see someone outside to direct you. And if you're interested in session B, you remain right here in this hall. The plenary sessions, the breakout sessions will end at 5. Hall 2, if you're interested in unilateralism, multilateralism, and the New World Order, please go to Hall 2. Unilateralism, multilateralism, and the New World Order, please go to Hall 2. And if you're interested in transnational financial governance and policy coordination, please remain here. The plenary sessions, the breakout sessions will end at 5. And after that, we'll gather for lunch. Thank you very much. Please, let's make it snappy. The plenary sessions will end at 5. Please, let's make it snappy. Let's move quickly. If you are interested in plenary session 2, please go to hall 2. And if you are interested in session A, please stay right here.
But people have left. People have left. There's no point. Yes, now it was good. When they were 6 months, and then we'll just everything. Oh well.
Yes, okay. Please kindly help us move forward so that as the presenters start their presentation, you can hear them and you can also be able to participate well.
Okay, please, let's settle down so that we can proceed on time and even leave our lunch on time. Hello, okay. Please let there be orderliness. Please, students, you can do that later, okay? Please, you can do that later. All right. Let me welcome us all to this session. It's going to be brief and straight to the point, but I will crave our indulgence to pay attention because there may be certain issues that may inspire further interrogation on what you have heard. Now, in this session, it is titled Transnational Financial Governance and Policy Coordination. And we are going to split the session into two. We are going to have a paper presentation whereby our two resource persons will talk to their papers in less than 9 minutes so that it can afford you the opportunity to ask questions and maybe engage them. And then the other session, we are going to have our set of speakers that we are going to have an interactive session with. So please permit me to start by calling the speakers that will be engaging here. We are going to start first by inviting Dr. Anita Wotite. Please bear with me if I must pronounce your name very well. A senior lecturer in the Faculty of Law, Nnamdi Azikiwe University. Please put a round of applause. Please clap for her. She's going to present a paper. And the next person, please sit here, welcome. The next person we are going to invite is Dr. Victor Ayeni, Associate Professor with Adekunle Ajasin University. Please, sir, kindly come up to the podium. Please put a round of applause for him, clap for him. I don't know whether Dr. Akinwumi Oguranti is around. He's the person we are going to invite as another speaker. He's Assistant Professor of Law at the University of Manitoba. Please put a round of applause for him. Now, without wasting much time, I would like to invite Dr. Anita to open the floor. You will speak to your paper in 8 minutes, straight to the point. Please pay attention so that you can engage her if there is the need for that. Okay.
Good day, ladies and gentlemen. Please permit me to stand on the already existing protocol. I wouldn't want to take much of your time because time is no longer by our side. I will begin by posing this. Imagine a system where billions of naira or dollars generated in Nigeria never reaches Nigeria. Not because the funds were lost, but because they are hidden. I just want you to imagine that type of situation. Offshore finances and tax havens are one of the significant threats. One very significant, but then invisible threat that the Nigerian economy is facing. Hence, the aim of this paper is to examine the challenges of offshore finances and tax havens. to the Nigerian economy. And I frame the title of my question thus, of my paper thus: the role of international law in regulating Nigeria's offshore finance and tax havens. Yes, this paper, or the title of this paper, is born out of the many threats that offshore finance and tax havens are posing to the Nigerian economy, particularly because Nigeria is also one of the developing economies. We have, through the lectures, through the papers, through the resource persons who have spoken today, heard so much about illicit financial flows. We have also heard of offshore finance and tax haven. But it is also important that we clarify these concepts. First, when you hear about offshore finance, we are simply talking about an arrangement of financial activities where persons or companies maintain their finances outside of the countries where those finances are generated. We talk about tax havens. They are those jurisdictions or countries that provide low or no tax on incomes. They also have or provide limited information about the funds coming into the jurisdiction. And these activities performed by way of bank accounts, trusts, or other ways of pushing or transferring funds. We understand that these developing economies, like every other economy, depend so much on tax for their infrastructural development and other things. Where these funds are pushed in such a way that the eyes cannot see them or they cannot be tracked. You see, a lot of funds are being wasted. And monies that would have gone into the development where the citizens should have benefited from this fund, they are removed from them. Now, this in Nigeria is not happening because Nigeria does not have regulatory framework. In Nigeria, against corruption by the regulations provided under the common reporting system, by the also provisions also provided under the Financial Action Task Force. Although we could say that the Financial Task Force is not a binding instrument, but this also binds our integrity and also ensures that the obligations we have at the international level or by virtue of the treaties and conventions that we have been able to enter into or to adopt as a sovereign state, that we are able to keep them. So I believe that international law has a key role to play in order to fill the gap that are there present in our own domestic system and institutional framework. By so doing, we have a robust laws and institutional framework that will go a long way to arrest illicit and offshore finances, because offshore finances are not inherently illegal, but then using them as a vehicle for moving funds that are made for the public is what makes it illegal, because of the loopholes that exist in the laws and in the legal framework. Thank you very much.
Please, a round of applause for Dr. Anita. That's a very good presentation, and thank you for keeping to time. We appreciate that. She has spoken about offshore finance and havens. Please, you can keep any question you have with respect to that paper presentation. At the appropriate time, we'll give you a time to ask questions. But at the earlier presentation, one of the moderators had made a very sound remark that lawyers are at the center of all illicit financial transfer. And at the back, while that comment was made, there were a suspicion as to no, yes, oh. But I think the next paper is going to tell us what are the roles of lawyers with respect to illicit transfer of funds. And this task will be done by Dr. Victor Ayeni from Adekunle Ajasi University. Let me welcome you, sir, to the podium. Thank you. A round of applause for him, please.
Thank you very much, Mr. Moderator, for the opportunity. Distinguished delegates, my presentation focuses on anti-money laundering compliance within the Nigerian legal profession. And the people will argue for the development of a well-structured, self-regulatory framework as the most effective and sustainable approach going forward. Anti-money laundering and counter-terrorism financing is no longer a peripheral concern for the legal profession. It is now a defining question of professional responsibility, institutional integrity, and national security. Lawyers today do not merely interpret the law, we structure transactions and create legal vehicles through which money flows. That is precisely why lawyers have become so central to the AML institutional architecture. And like the moderator said, when lawyers do their job, we have the opportunity of addressing significant number of money laundering incidents. So we have several examples, such as the Alibatin scandal that has been that is quite popular, which involved bribery that was paid between 1994 and 2004, running into 180 million USD to bribe government officials so that they can give contract worth $6 billion US. And the process of doing this involves several lawyers who were acting as intermediaries. So it has become very important for lawyers to play a role, but the purpose of this paper is to draw our attention to one crucial factor. Initially, when this effort was made to incorporate lawyers into AML compliance, there was a pushback and resistance from lawyers on grounds terms of client counsel confidentiality, professional legal privilege, and the constitutional guarantee of privacy. This will use in various decisions of courts to exclude lawyers from direct obligation under the various EML framework. So I'll be presenting to you today like an alternative to those framework, which I believe will achieve the same result. So before I do that, as a background, the standard for EML compliance is provided by the Financial Action Task Force, which issued 40 recommendations that are supposed to govern illicit funds transfer and money laundering compliance in general. But recommendation 22 is the one that relates to lawyers, recommendation 22. And this recommendation specifically requires that when lawyers are carrying out 5 activities or 5 transactions, they are supposed to observe due diligence, record keeping, suspicion transaction reporting, and other risk-based compliance measures. What are these transactions? One is real estate transaction, company formation, management of clients' funds, and management of bank accounts, and then buying and selling of business entities. For these 5 types of transaction, the Financial Action Task Force requires, under recommendation 22, that lawyers must uphold customer or client due diligence. And for this reason, lawyers were designated non-financial business and profession under the recommendation 22. My apologies. So based on this recommendation 22 and the whole of the 40 recommendations, the Nigerian government has responded starting in 2011 through the Money Laundering Prevention and Prohibition Act and then the Terrorism Prevention and Prohibition Act. Then this legislation was amended in 2022, all of them, and then we have, in addition to this, the Proceeds of Crime Act. Then some institutions were put in place, the EFCC, SCULO, the NFIU, all to implement the recommendations of the Financial Action Task Force. But there was a problem with this process, which is what I call a constitutional tension. The tension is the attempt to designate lawyers under the supervisory authority of the EFCC and SCULO to ensure that lawyers' accounts, clients' accounts are supervised, that lawyers report directly to NFIUs. Several cases were filed. We have the CBN versus Registered Trustee of NBA, and then the Federal Republic of Nigeria and Chief Michael Zekome, where those provisions under the 2011 Money Laundering Act was struck down. But also under the 2022 Act, there was a case that was filed, Abu Arumi versus Central Bank of Nigeria, where the court clearly and decisively said that EML reporting to lawyers in those manners that are stated in the Money Laundering Law or Act and the various legislation violated legal professional privilege. It undermined right of privacy and eroded duty of confidentiality. When many lawyers heard this judgment, they just ran and said, from this point onward, we are no longer obligated towards the EML compliance. But my information is that what I'm here to tell you is that this does not mean that we are no longer required to comply with EML obligations. However, the obligations, instead of being put on us by external regulators, it is now something we have to do ourselves. So first of all, in 2023, the Rules of Professional Conduct provides a new chapter which details the guidelines on EML compliance. That is the first step. Then the NBA created the NBA Anti-Money Laundering Committee, which has issued guidelines and conducted training and raised awareness on EML compliance in Nigeria. So, but currently the committee does not do systematic inspection, there is no structural reporting architecture, no enforcement level, and without these, compliance will remain aspirational but not operational. So my central argument is that there is a need to strengthen the NBA anti-money laundering committee to make it work effectively. So I am making a number of proposals in order for us to achieve this. The first one is to transform the NBA anti-money laundering committee from a sensitization and awareness creation body to a truly supervisory authority with statutory backing, inspection powers, and enforcement linkage linked to the LPDC while addressing concerns about its independence and capacity. While the NBA Anti-Money Laundering Committee represents an important step towards professional self-regulation, there is no question that its current design is not sufficient to carry the full weight of EML supervision. So that brings me to my second recommendation, which is to establish an independent, professional-led LPPC or LPDC-style EML regulatory authority with clear powers for inspection, compliance monitoring, and sanctions through amendment of the Legal Practitioners Act, which is currently taking place. The amendment is happening currently. Another recommendation I'm making is to integrate AML violation into professional misconduct, formally classifying AML breaches such as failure to carry out due diligence and facilitation of suspicious transaction as professional misconduct. Mandate firm-level compliance, meaning at the level of the law firm, there should be AML compliance. Introduction of a mandatory annual AML compliance returns for legal practitioners and law firms, indicating whether the firm has designated a compliance officer and other information related to AML compliance. Also, requesting each law firm to designate a compliance lead, an AML's compliance officer responsible for AML obligations within the firm. Again, introduction of mandatory annual AML continuing legal education, which will require lawyers to complete this minimum AML training hours annually. Introduction of risk-based supervision and inspection, which focuses on law firms that are involved in cross-border transactions, real estate, and company formation transactions. In conclusion, the committee can also develop templates for client identification and due diligence so as to help law firms do AML compliance properly. Finally, AML compliance should be embedded into legal education. The Nigerian Law School should place emphasis on it in the professional ethics, and then the various faculties of law are encouraged to maybe introduce a compulsory course in this regard. So I want to close with this, that Nigeria currently stands at a critical reflection point. We have to move from denial to resistance, and from resistance to early stage self-regulation. The next step is decisive. We must move to structured, credible, and enforceable self-regulation, because a profession that does not regulate itself will eventually be regulated by others. AML compliance is not an attack on the legal profession, it is a test of our integrity. Confidentiality must be protected, but it must never become a shield for illegality. The question is no longer whether lawyers are part of the AML framework. The real question is, will we shape that framework ourselves or allow others to define it for us? Thank you very much.
A round of applause. Thank you, Professor Yini, for that wonderful presentation. Please bear with us. We will make you to be raising your presentation. We were trying to comply with time, so okay. Thank you very much. The president earlier on today said that the issue of tax evasion is not only a crime, it's a matter of human rights violation. And in that direction, we have somebody that has a paper that is going to present that will address human rights treaty relating to illicit finance. And that's one of our resource persons in the person of Dr. Akinwumi Oguanti, Associate Assistant Professor of Law at the University of Mandiba. Please, the stage is yours. Thank you. If you can sit down, please.
Thank you, Matthew. First, I'd like to thank you for inviting me, because I know we must have sent over 100 emails about coming here, so thank you so much. my paper talks about the linkage between international investment law and illicit financial flow. And I must add the caveat here that the paper is still in progress. So I'll give you more questions than answers in this presentation. But what I would like to do is to provoke your thoughts, also to introduce you to international investment norms that may appear neutral, but in themselves, they pose some challenges to the development of African states. I think let's start with illicit financial flow. I don't want to flog the issue because illicit financial flow, has been defined in the various in panels today. But it's even more difficult because it poses a challenge to African states. And I think the UN put it to say that illicit financial flow is more problematic for African countries, and it poses a survival challenge, right? So the question becomes, if there is a threat to the survival of African states because of the financial flow from Africa to developed countries, how do we then reimagine international law, right, to address that challenge? And so, because the problem is more important because it poses a challenge to sustainable development, right? And so what I did in my paper was to think about international law, and specifically international investment law, right? So international investment law deals with regulation of foreign direct investment in Africa, say for example in Nigeria. Then the question becomes, to what extent do these rules, these norms, facilitate or help to help multinational corporations to transfer wealth from African countries to developed countries? So when you look at the history of international investment law in itself, you see that international investment law rules were created to facilitate capital flight from developing countries to developed countries, right? And you see that in the 19th century, neoliberal laws or norms were created, and it's been criticized by many scholars. When you look at the likes of James Gattin, Pierre Okafor, you see them constantly pushing back at the Western norms that are designed to actually make African or developing countries impoverished in many ways, right? So the capital flow in the 19th century we saw then now is being changed in the form of illicit financial flow. Because right now you see that we've talked about treaties, we've talked about laws that are in place, but you see that multinational corporations, they layer their structure to the extent that they put in place mechanisms that allow them to transfer wealth, sometimes illegally, from African countries to developed countries. So my paper then asks, how should we reimagine or reframe international investment law? I draw on a cosmopolitan theory, which states that every individual, wherever they are entitled to that survival means to actually function in society. So when you think about a cosmopolitan theory in this way, I then ask myself, how should we then reframe international investment law rules to ensure that when a multinational corporation is dealing or doing IFF, how should we then enforce international norms, right? Because the reason why I say this is, if we think about international IFF as a challenge to rights to development of African countries, and right to development, it's been debated by many scholars. But my argument is that if we think about illicit financial flow as a human rights challenge or abuse, then how should international investment arbitration tribunals deal with these issues, right? And what one solution or one proposal that I'm thinking about, and which of course I'm still researching on, is to think about how norms like fair and equitable standard, equitable treatment standards came into place in the 19th century to protect foreign investors. Are there ways to also create norms like that that protects African countries from abuses, human rights abuses in this manner? Because I've characterized IFF as a challenge to right development. So how do we then characterize norms that then protect the interest of African states to development? I argue that if a multinational corporation is involved in illicit financial flow, then arbitration tribunals should be empowered to either give remedy, just like it would do for FET standards if they were breached by African states. And so if they were to give remedy for African states for illicit financial flow, number one, arbitral awards can be reduced. Arbitral claims by foreign investors can also be refused if a foreign investor is involved in illicit financial crimes. And I argue that conceptualizing norms like this rebalances that inequity that occurs in international investment law. Because as you notice, international investment law is skewed in the favor of multinational corporations or even foreign investors. And so when we think about international IFF as a human right, as a challenge to right to development, and the arbitral tribunals actually factor in these considerations in their awards, then it creates a regime that is fair, that is equitable, and that is more balanced in international law. And so this is just me provoking your thought and giving you some of my ideas, for which, of course, I'd have to develop over the months. But I hope some of you who are interested in international investment law will think about this and carry this forward. Thank you so much.
Thank you, Dr. Akimu, for provoking our thoughts. And I think one of the areas that you've made me to recap was the argument whether corruption, offense of corruption, should be a subject of customary international law. Because it is said that if the global community is serious about combating corruption, they should make it a crime against humanity that will have a status of customary international law. And I think it is still debatable. The other thing that you were talking about that I think is supposed to provoke reaction is the dependence, view. People like Walter Rodney, that he said corruption is designed to perpetrate, illicit flow of funds is designed to perpetrate capital flight from developing countries to developed countries. And that's what people like Walter Rodney in their book are saying, that how Europe underdeveloped Africa is a relationship between satellite and metropole, whereby the metropole drains the resources from the political elite of the satellite states. And so we found ourselves as Africans. Let me just give this stage to all our audience. If you can have 1 or 3 questions, 2 or 3 questions to address this concern. Yes, I see a hand there. Yes, we shall be, okay, we're having 4 people. We're having another session. Please bear with us, We're having another session. Just go straight to the point. Yes, let me share the exchange to them. Go around. Hello, media team. Let me see this lady, this gentleman, this lady. Okay, the 2 of you, please go straight to the point. 20 seconds for questions. Collect the mic.
I want to thank our presenters, and I'll just go straight to what I want to say. It may seem a bit abstract, but you have to bear with me, because we're talking about anti-money laundering laws, tax evasion, and then corruption. We as Nigerians, we as Africans, I'm sure that if we are asked to define corruption in our respective languages, nobody can tell us what that means. So it is all collected, and we learned it from the international world. And I'm sure that many of us here who have traveled abroad will see that all the things that made Africa what we are have been stolen and used to develop the international world. So for us standing here to ask them for a solution on how we are going to mitigate economic and financial crimes, we cannot get anywhere because they want us to even be more corrupt so that they can steal whatever we have from here. So asking the international world to give us solution on how to curb corruption in this country, it will not work. So my suggestion and my personal opinion is that let us go to the roots. Let us start with our children. Let us go back to what Nigeria was, what we are. We were truthful, we were honest, we were intelligent until we gave room for the international world to come and teach us corruption. And that is why we have not gotten out of it. Thank you.
Okay, thank you very much. Yes. Give it to the next lady there. She's close by. They will come to you, gentlemen, don't worry. Please, straight to the point.
I have a question and a comment. So the comment is based on what you said, the moderator. You said lawyers are in the middle of every illicit transfer. If illicit transfer depends on the legal structuring, that clearly mirrors the failure in state regulation rather than the misconduct of legal practitioners. Because if you can exploit the system legally, the problem is the law and not the lawyers. Now, my question is based on what the first speaker said. Why are strict financial compliance standards imposed on developing countries while major economies face limited consequences for similar breach? For example, developing countries are pressured to tax reforms and increase in transparency, while yet major financial centers, e.g. the offshore jurisdiction, continues to enable tax avoidance legally.
Okay, thank you very much. Yes, give it to the next person there. There's a lady there, then give it to him.
Okay, I want to first of all thank the speakers for a very insightful session. Then my question is for Dr. Akinwumi. When he was speaking, he made a major proposal for human rights treaty in relation to IFFs, and he said that he was looking at creating norms to prevent African countries' interest against violations relating to IFFs. And I want to ask that, obviously, when we're talking about international investments, there are also like benefits that come with the multinationals' interest in developing countries' economy. And even if the benefits may not really outweigh the exploitation, I want to ask, are those norms also going to factor in those benefits that are coming? Thank you.
Thank you. Yes. Give it to the last person there. Then moderators, you should be able to help us.
Good afternoon, everyone. My question is directed to Dr. Victor Oyedi. So, talking about the compliance of the AML, and I've been speaking from a legal practitioner's perspective. And, you know, we have the laws are there. And talking about the compliance, we are all aware about the relationship between the lawyer and his client, which is fiduciary in nature. Here is my question. How do I report an alleged suspicious transaction committed by my client without losing my clientele? That is my question. Thank you.
Okay, thank you very much. Let me give them so that they can start addressing the question.
So, thank you very much for your question. If I heard you very well, your question is why the transparency compliance is more on the developing countries than on the developed countries. If you look very well, you will notice that the developing countries are more of rule takers, right? The developed countries have already fashioned for themselves a system that works for them. We are much dependent on them. than on our own rules. We are better inclined to listening to them and seeing how they do things, and they are there making laws, making regulations for us on the way forward and on the way we undertake our things. So more or less, we see them as a kind of, in quotes, as a kind of models for us. So they are there as the Lord making rules for us, and we're there taking the rules because we have fashioned our ways, some of our laws, and the way we do our things in accordance with their own standard.
Thank you. Give it to Dr. Eni and Victor.
Okay, thank you very much. Just to make a quick point on the question regarding whether if you exploit the law legally, that the problem is the law, not the legal practitioner. In addressing anti-money laundering problems, it has been globally accepted that there are two gatekeepers: financial institutions, banks, and other institutions like that. Then the second ones are the designated non-financial businesses and professions, where we belong, lawyers. These are the two gatekeepers. And for our category, it includes accountants, casino owners, people that want to sell precious minerals or precious stones, gold, and other things like that. We are in the same category. So EMI compliance is extended to us because we are gatekeepers. That is one. Then secondly, to answer the question over there, how do I report an alleged suspicious transaction without losing my client? Here we are suggesting suspicious transaction reporting at 2 levels now. Within your law firm, you should have a compliance officer that will trigger or alert you that this client or this transaction falls under this process. Then internally, you should have an internal compliance mechanism so that within the law firm you can discuss. Then secondly, we want the compliance reporting to remain within the legal profession. So we report within the legal profession. And then it can later be escalated to NFIU or SCOMO later. We do not, so those external bodies will no longer have access to your law firm, and we do not need to report to them directly. So your client is safe.
Thank you, sir.
Thank you very much.
Can you please help us straight?
So I would answer two answers, and I think the first comment about why do we need international law? Why do we need the West to give us? I think my response to this, and I want to play a devil's advocate, because I published a paper 2 months ago titled "No One Is Coming to Save You," and it's basically what you just said, that look, we can't look to international law. But on the other hand, we must ensure that international legal rules, as it applies to us, are neutral, they are fair, and they are just, right? Africa cannot isolate itself from international law. It's just a global order, and they can either be the meat on the table or participant on the table. It has to be one, right? But in becoming participant at the table, we must ensure that the rules are fair. And that's the essence of my paper right now, to say that the rules must be fair. The second one, about won't we lose foreign investors if we have norms that balances the rights of investors and an African state? My response is this: we are worse off anyway.
Okay.
Because 2 seconds, and the reason is that right to development, illicit financial flow is negatively affecting us. So should we then do nothing because we want to invite foreign investors or even make ourselves available? And that's a debate in international investment law. Some scholars would say, well, international investment law contributes to a country's GDP, but there's no evidence of that.
Okay.
But we cannot just sit down to say this is affecting us negatively. We shouldn't do nothing because we want foreign investors.
Okay, thank you very much. She asked a question straight. Yes, it was a statement that was made by the former moderator, and I capitulated upon it to introduce the next topic. But factually, you can check. Internationally, there are law firms in Mexico and other areas that are, through illicit funds, engaged in drug trafficking, terrorism, financing terrorism. And even in Nigeria, we have lawyers that are currently undergoing disciplinary procedure relating to the issue of illicit transfer, okay? So permit me to come to the conclusion of this session, and I want you please to give a round of applause to all our wonderful speakers. They've done well. I will just give you guys a brief minute to go and sit down as we usher in the next session of young scholars that will be making presentation. After that, we will have our own collective mission. Now, the next session of this program is going to be an interesting one. And it is interesting because it has to do with the Gen Zs. And there are also plenty of Gen Zs here. So we never heard about cryptocurrency. We never heard about artificial intelligence. So we are going to invite them to come and tell us what about this and how are those latest terms related to illicit flow of funds, and how can we use them to also track, trace, detect, and prevent illicit transfer of funds. Now, I will be inviting Abraham Adeniran, who is a lecturer with Afe Babalola University. Please come to the podium. And also, a vibrant young man, a prospective international scholar, Latuna Adedeji. Please come here and sit. Let's discuss. What do you have to tell us? I will give you the opportunity to introduce yourself. Mr. Abraham, Latuna, please sit here and then tell us briefly about your topic, okay?
Thank you very much, and good afternoon, everyone. My name is Abraham Adeniro. Though I'm not a lecturer, but I'm a doctoral candidate from the Durban University of Technology in South Africa, and I'm also a research associate with the OG's Institute in Afe Babalola University. While my core area of specialization is in financial economics, energy economics, I also do research around energy financing, technology, the economies around technology itself. Thank you very much.
Yes, you want to tell us about yourself?
Yes, good evening. My name is Latuna Adedeji, and at the moment, I would say I'm a lawyer in equity. And what I say so is I'm not going to law school, but I'm a law graduate. I currently work at EAP. I work as an executive assistant to senior advocates. And in my own personal career, I would say that I'm currently building a big profession in the energy, infrastructure, and finance industry. And just like Mr. Abraham, I'm also a research associate at the Institute for Oil, Gas, Energy, and Institute for Oil, Gas, Energy, Environment, and Sustainable Development. Yes. And I'm very happy to get
to Mike. Mr. Abraham, you are writing on cryptocurrency as how does international law regulate cryptocurrency with specific respect to Africa. Can you tell us what is cryptocurrency to break it down to the level of our audience?
Thank you very much, sir. Cryptocurrency, in a very plain term, is a digital representation of monetary value that can be transferred electronically. It can be used for payments, it can be used as a means of investment, and it can also serve as a way to store value. It's also a means of, it can also serve as a means of settlement. So I would say under the law in Nigeria, the Nigerian SEC rules on issuance, offering, platform, and custody of digital assets 2022 defines virtual assets as a digital representation of value that can be transferred, digitally traded, and used for payments or investment purposes.
You talk about digital assets. That will take me to another thing. Do we have any regulatory framework in Nigeria, Africa, or West Africa to understanding that governs cryptocurrency? If you can give us any that you know, so that we will be enlightened more.
Okay, so I would say, let me take it from the global perspective. Globally, it's the Financial Action Task Force that is regulating issues around cryptocurrency. globally. And according to the FATS, shortly named, I mean, it's named FATS. They have 40 sets of recommendation, and in the recommendation, in the 15th recommendation of the FATS, the financial assets are clearly defined, and so globally, most countries tend to adopt the FATS F definition of cryptocurrency, especially when it comes to money, when it's related to transactions and money laundering. And in Africa, generally, there is no single law, there is no single regulation. What we have are parchments of individual country laws. Well, in the Eastern and Southern Africa, we have the SMO, where they tend to also provide oversight on cryptocurrency trading, money laundering issues, and just like we also have their Western African counterpart, GIABA, which are also enforcing. They are pressure groups. I'll call them pressure groups that tends to regulate. Even though there's still a lot of issues around enforcement, but they are playing critical roles when it comes to supporting and mitigating issues around money laundering and risk that might arise from adoption and the use of cryptocurrency in West Africa. Thank you.
Now, with respect to Nigeria, what are the institutions, if any, that regulates virtual digital assets? And if you can tell us how, in your own assessment, how are those institutions?
Okay, so I'd say in Nigeria, I think just like I mentioned earlier, that of course we have the Security Exchange Commission rules on issuance, offering, platform, and custody of digital assets, which of course, that was the 2022 regulation, basically, which defined assets as a digital representative. So we have, so they are playing a critical role when it comes to regulations, when it comes to defining code. Just recently, we know during the President Buhari era, cryptocurrency was totally banned because of it was highly cited that a lot of money laundering issues were occurring during that era. But now we are moving towards a more defined regulations, even though there are still many issues around compliance here in Nigeria. And one of them is the issues around identifying virtual assets service providers. Basically, there are also, so I think I would say in Nigeria we are partially compliant with the FATF, the Financial Action Task Force Regulation 15. Yes, so recently we've been classified as financially, even though there are still a lot of issues, but we are gradually moving towards a definite or a defined regulatory framework.
Let me ask you this question. There's a common saying relating to cryptocurrency that crypto as a non-physical asset can be translated into physical assets. How can you relate this assertion with respect to illicit flow of funds?
Okay, thank you very much, sir. Yes, the way cryptocurrency itself is, in terms of illicit money laundering, or in terms of money laundering, it's a means to an end. So it's mostly occurred in hybrid version. It's not as if the entire transaction occurs, within the crypto or within the virtual space. So it's an hybrid of. There are different layers. Let me say there are different layers to it. For instance, many people, because of the faster way of transaction, you see someone get in touch with another peer, get in touch with another person, and then you get in touch with another person, and then they send the money out, and you are still going to pay using the normal fiat or normal money. But of course, Yeah, so I would say that it's an hybrid way. So it's not as if the whole transaction occurs within the crypto or within the blockchain environment. But rather, you know, it's a marriage between, you know, the physical way of transaction and the virtual transactions, basically.
Okay, thank you, Abraham. Latona, tell us something about your topic titled Generative Artificial Intelligence in the Nigerian Socio-Economic Landscape, the role of international law in balancing transformative benefit in finance, law, and education. Please, can you tell us what is generative artificial intelligence?
Okay, thank you very much for the question, sir. So, I want to mention that a lot of people misconstrue the meaning of generative AI for AI itself. You need to understand that over time, we have moved from artificial intelligence to generative artificial intelligence. The reason why a lot of us now find so much comfort in watching some of these videos we see on TikTok and all social media platforms has been because of the use of generative AI. As the students not very long ago, the reason why solving assignments or even doing research has become a little bit more easier is because the developers behind artificial intelligence moved from just AI to generative AI. So generative AI asks me, what is it? Generative AI is an AI that is self-aware and can imagine like a human being. So the reason why many people have CEOs coming out these days to debunk videos where you could see the CEO themselves speaking with the original voice and every function of the body is like them, is because they have an AI that can see you and replicate you like you and do everything like you. So these AIs, they really need much points. All they need is a sample. Or like before they need to feed on a lot of information, generative AI now, then almost all the technologies that we have, they study the environment and they can replicate the environment so easily.
Okay.
So the reason why in some ways is an advancement of the AI not so easily.
Okay. Now, can you tell us what is the interface between generative AI, law, and finance in relation to the mitigating economic and financial crime?
Okay, sir. I remember some of the ideas there is a view that what is it that they say in the face of all these illicit transactions, we have legal practitioners there. So the truth is, AI is here, but AI is like, how do I put it? AI would like launch into the city, evolve into the city, looking for ways and more strength, looking for the same thing to regulate it. AI is everybody is complaining that this thing, how do we control it? And the joke is on the road because we keep making more AIs. Because AI now is needed in